Our second interview is with Richard Eymann, a Spokane attorney and lead trial attorney for the Hanford Downwinders.
We are interviewing Richard Eymann. It is April 29th in 2019. We're in Spokane, Washington at the Patsy Clark Mansion. Dick, may I call you Dick?
Dick or Richard's fine.
Perfect. Okay, Richard. What type of law did you practice prior to becoming involved in the Hanford Downwinder litigation?
Except for the very first job I had out of law school working for a defense firm, which lasted about 6 months. I've been a plaintiff's lawyer ever since. I do not represent insurance companies, nor do I represent large corporations.
Okay.
And so I essentially have been representing those who have been victims of other people's wrongs.
Okay. Can you, for people who may not be acquainted with the Hanford Downwinder litigation, can you tell us a little bit about that litigation, how many people were involved, what it's all about?
Well, let's start with the fact probably you've had other persons who have spoke about when Hanford started, but anyway, it started building the place in about at the end of 1942, and they were online to produce plutonium by I think September 1944. This was part of the Manhattan Project. It totally changed the entire area of what is known as Richland, Kennewick, Pasco, Washington. I believe they brought in 50,000 workers to build Hanford, and most of the people had no idea even what they were building when they built it, except that the contractors, which was DuPont at that time, which was on essentially a contract with the United States to create what turned out to be the atomic bomb. And so that's how it got started. Obviously, this was before Chernobyl, this was before Fukushima, it was before 3 Mile Island. Hanford itself is, I think, 580 square miles of essentially sagebrush scrubland, and they turned it into a manufacturing plant of essentially plutonium, which then was used in the bombs that were dropped on Japan. So at some point thereafter, although there were suspicions among those who were in charge of Hanford, those who were operating it, and by the way, DuPont got out of it early on and turned it over to other contractors, but essentially the secret of Hanford was kept until the late 1980s, in which FOIA requests, and one of which was a spokesman review in Spokane, sought information about really what had been done at Hanford and whether or not there had been releases of any radiation. And out of that, it came to be that incredible amounts of radiation had been released from Hanford, especially in the early days, starting in 1944, continuing very heavily into the early 1950s, at least of iodine-131, and there's a whole entire story behind that. Obviously, you've asked probably other persons who have been interviewed about what happened back when. But moving forward to your question with regard to the litigation, once it was determined that many, thousands in fact, possibly 15,000 to 25,000 people were exposed to radiation as downwinders, in other words, off campus from what was known as the Hanford Reservation. And given the fact that mysteriously for all these years, people had been having diseases or problems that were thyroid related, such as hypothyroidism, such as thyroid cancer. There was then a rush among some lawyers, I was not one of them, to sign up essentially persons who felt that they had been harmed by Hanford. And that led to essentially even lawyers going town to town, downwind. Now downwind, what does that mean? downwind from Hanford is an interesting question. The government looked at it one way, and just to show you, the government's interpretation of Hanford as shown here. This shows the Hanford Reservation. Their interpretation of those that were downwind was essentially a small area just around Hanford itself. The real story shown here is that all of this area received radiation from Hanford. Hanford is the small white dot here, and through different studies that had been done, and this one is the government study, which is, I think, has been proven to be quite erroneous. It gave doses, and you can see that those doses immediately right next to Hanford had 100 to 235 rads. If you happen to be a young child aged from birth up until probably 10 years old, you would be subjected to 135 rads. Now I say that, and to put that in context as far as the litigation is concerned, this was the government's interpretation of the exposure to the dose that was to these particular young adults downward to those at birth. And so you can see we're sitting in Spokane today, and Spokane is sitting on the edge of what they said at that time was essentially 3.2 rads down to 10 rads. Later experts, especially those that were brought in by the plaintiffs in this particular case, found out that this was underestimated on a frame of like 1 to 8. In other words, 8 times as much radiation exposure to these people as was indicated by the government. One of the big things that arose out of the fact that all of a sudden there was a case against the contractors and essentially the United States government, which was defending. And there's a story behind that. But essentially, the government agreed at the very start of this to indemnify the contractors for any harm that might occur to any individual. And so essentially, the litigation itself was defended essentially by the Department of Energy of the United States and the United States itself. There's a whole story behind that, and I don't mean to digress from your question, but to give you some background, there were 2 studies that were done, HTDS and HEDER, and both those were funded by the United States. Both were worked on by persons who actually worked at Hanford, okay, or had connections with Hanford. And so as the litigation went on, which I presume you'll be asking more questions about, we learned that both of those particular studies, which were used heavily in the litigation by the defense, really grossly underestimated the dose that these toddlers, these kids, even young teenagers had been receiving at Hanford.
How many years of releases are you talking about here? It started in late 1994, and how long did these airborne and riverborne releases continue?
Well, that requires a complex answer. It depends on the radionuclide. For some of these, like radioactive zinc, okay, the half-life, and I'm sure you've had scientists that have already discussed for purposes of these interviews what the half-life is. But for, I think it's, I can't remember the number, but for the zinc isotope, the half-life is like 27,000 years. So if you're eating oysters out of Willapa Bay on the coast of Washington, personally, I wouldn't do it. I stopped eating oysters from the coast of Washington because the zinc readings of the isotopes for zinc are highest there as any place in the world. including anything that was downriver from Chernobyl. So with regard to other radioisotopes, and essentially what the main litigation in this case centered around was iodine-131, which has a much shorter half-life. But essentially, there were two avenues to radiation. They built Hanford. They needed to cool the water for the production of plutonium. Without something to cool the plants as they conducted the process, you could have essentially the entire plant blow up. It almost went crazy like that at 3 Mile Island. It did at Chernobyl. And so without protective cold water, that's why Hanford was picked. Okay, it was a remote area, and you had plenty of water in the Columbia River. So what I'm alluding to is the fact that there's two ways for the radioactive isotopes, of which there's many different ones. One would be through the air, and another one would be into the river water, because they circulated the river water out of the Columbia and then through the cooling portion of the plant and then back into the river. Various isotopes of radiation was going into the Columbia River. Okay, and so I'm probably digressing from your question, but when it goes into the air, you have something called the milk pathway. That's a very popular term, not popular. It is a term that's used about how these downwinders, these kids and adults, everyone who lived downwind, contracted or had radioactive iodine get into their bloodstream. And when it gets into their bloodstream, which what it does is it goes to that gland in the human body that really wants iodine and looks for iodine and pulls iodine out of the bloodstream into the thyroid gland. That happens with or without radiation being in the iodine. So the way that happens essentially is that when it comes out of the stack as shown here, you have this gas, okay? The radioactive material, after it comes out as a gas, starts to fall, okay? And it falls all the way to the ground, okay? When it falls to the ground, it would get into the grass, okay, or fall on the grass. Cows, okay, would eat the grass. Goats too, okay, because there were a lot of goats around Hanford before Hanford ever existed. In fact, it was one of the largest population of goats that existed at that time in the United States. But in any event, goats and cows would eat the grass. Okay, once they ate the grass, cows were very good at taking the radioactive isotopes and putting it into their milk. Once it got into the milk, as long as it was fresh milk delivered throughout all of eastern Washington, northern Oregon, and into all of northern Idaho. At that time, and I was a kid, I was born in 1945, if you didn't drink milk, you weren't going to grow up to be big and strong, or you weren't going to grow up to be pretty, or you were, you know, parents pushed milk, and so kids drank milk. It was nothing at that time, like for myself, to drink, you know, 5 or 6 glasses of milk a day, okay? You had milk with breakfast, you had milk at school, coming in these little carnation cartons, and you would have 2 or 3 glasses of milk at night, okay? Did they have water in those days like this? No, okay? Nobody served water, okay? So for these kids, they drank milk. And myself, I was lucky. I was down in the Willamette Valley away from this radiation. And so once they were drinking the milk, they got the radioactivity into their system and it went to the thyroid. So that's the pathway. Now, the other pathway that you asked about was the river water. And if it got into the river water, fish eat, especially bottom fish. Those that hang around and don't go out to sea, such as the salmon, but those who are like native whitefish, they eat what's available in the river. And they were essentially eating radioisotopes. At those days, nobody said the fish that you caught was bad fish. Nobody said that if you were eating fish that it was unhealthy for you. In fact, today, nutritionists advise eating fish. Some people, a lot of people in Eastern Washington at that time were poor. And one thing that Columbia had was plenty of fish, whether it be salmon that would go out to sea and come back, or the native fish. A lot of families, that was their main meat diet, was fish. And so that's another way that they got radiation into their system, not radioactive iodine, other radionuclides. And that was a portion of the litigation that we never really got to in this particular case. And there's a whole entire, there's reasons for that. And it had to do more with the cost that it was, the cost that, or the expenses of this litigation for the plaintiff's lawyers, that we never really were able to put the avenue of the radioactive materials that were getting into the Downwinders and essentially causing cancers. And I can say that the Department of Health recognized a significant number of cancers that were related to fish that the Department of Energy never would recognize and refused to recognize, and said that the Department of Health was just giving a free handout to these people who had different various kinds of brain cancer, bone cancer, pancreatic cancer, liver cancer, brain cancer, all these other cancers that the Department of Health related to Hanford for the workers, not for the Downwinders, but for the workers. The Department of Energy and the defense lawyers in this particular case refused to go there. And essentially, one of the largest disappointments for me in being involved in litigation for 20 plus years was we never really were able to bring that to the table. And I am sure there's been many people who have died from various cancers as a result of being exposed to fish, never were compensated, and something that obviously the government and anyone who produces these kinds of radionuclides should take attention to. Is that's the other avenue in getting sick and dying from cancer.
Did you, speaking of the thyroid disease clients, did you find that many of your clients had additional issues along with the thyroid disease, sort of like a syndrome of problems?
I would say a few. We did have those that had thyroid diseases and also then developed another cancer. The defense, the government in this particular case, refused to even look at the other cancers, and so during the course of the litigation we had to focus, based upon court decisions, on the thyroid diseases, the hypothyroidism, the thyroid cancer, and the other thyroid diseases. Interestingly enough, there would be some epidemiologists out there that would say that hyperthyroidism was also caused by Hanford. But you have to have, in these cases, you have to have the ability to prove that a particular disease was caused by the radioisotopes, the radioactive iodine, or whatever other radioisotope that was involved. And unfortunately, over the course of 22 years, we never got to that particular point where we could even settle cases for those kinds of cancers other than thyroid diseases.
Okay. Now, can you talk a bit about how long the litigation lasted and what the Bellwether Trials were?
essentially from the start to finish, I think it covered 24 years. I already alluded or already said that at the very beginning, certain lawyer firms who were accustomed to doing class actions or were environmental type lawyers like Tom Folds, what they did was go out and recruit downwinders to be plaintiffs. And unfortunately, I think the original number, which was used by the defense as a sword as opposed to anything else, was that there were 3,600 downwinder plaintiffs, of which approximately only half were legitimate. When those out in the communities felt that every little problem that they had might be related to Hanford, they would sign up. And as it turned out, a lot of the things that they felt were related were not. And so it went from probably 3,500 plaintiffs down to, I believe, at the time that everything got serious about litigating the cases, it was down to around 1,500 to 1,700 legitimate plaintiffs. That does not include all those who decided, I don't want to be involved in this. I don't like getting involved in litigation. And so those stepped away. Others were dead. They already died of thyroid cancer. Others moved away. Even to this day, my law firm is receiving phone calls and emails from those who just came down with thyroid cancer, who were toddlers, little kids living at Hanford during that period of time. And we are no longer taking these cases. It was a big economic, financial strain on my particular law firm, and probably on the other law firms that were involved, of which it really wound up being about, I think, 5 major law firms continued after original. I think there were 30 law firms originally involved, and it got down to 5 law firms that marched forward. And my law firm and the Tom Folds law firm, we were the last to be in this particular litigation that did last 24 years. So I can tell you a lot about the course of the litigation, but maybe I've already answered your question.
No, I think it would be helpful to people watching the video to know what a bellwether trial is for and how many there were in this litigation and what the result
There were
was.
2 bellwether trials. Bellwether is, it's called an experimental trial with real results for a very limited number of litigants. And it essentially is still used to this day by various law firms, especially those in class actions, pharmaceuticals, drugs, and things like that, to determine what would be an appropriate amount to compensate victims. Now, I should tell you that in this particular case, and I'm sure, I don't know whether you've asked questions about this, and I'm sure that some of those who have already been interviewed, such as Karen Doran Steele, probably has commented about the fact that the original judge, federal judge in this particular case, was with it for several years, and was he eventually recused himself from the particular case. He was shown to be in a conflict of interest. He has since passed away. But Judge McDonald was his name. But in any event, after he recused himself, Judge Frem Nielsen, federal judge Frem Nielsen in Spokane, took over the cases. And it was after that an agreement was reached among defense counsel and those remaining plaintiffs' counsel groups to see what a jury would do with the different types of diseases that had been allegedly, the government, I can tell you, didn't think anybody was injured by Hanford. And the plaintiffs thought significant numbers, in excess of 1,000, at least 1,500, maybe more, that were in the litigation had been harmed by Hanford. Well, the judge decided we'll have these trials, and essentially it started out with the plaintiffs picking cases that they thought would be good ones to try, and the defense picking ones that they thought should be tried. As it turned out, the defense picked essentially, if I remember correctly, 5 plaintiffs who were essentially still in the case and should not have been in the case. Their doses, based upon both plaintiffs' counsel and defense counsel, agreed that those doses were so low that given what we had to prove in the particular case, should not go forward to trial. The plaintiffs came up with 10 different plaintiffs. I had one in particular that I thought, and the rest of the counsel had 9. Out of those 10, the number was reduced down to 5. And during that period of time, with Judge Frame Nielsen on board, we had essentially agreed on a lead counsel for the case. Okay, that would be a counsel for the plaintiffs who would communicate with the judge and be the messenger to the other plaintiffs' groups. That was Louise Roselle. I had recommended her, and she was working for a Cincinnati law firm that was well experienced with regard to this kind of complex litigation, and as it turned out, she was excellent. Okay, me being from here and having had the kind of trials that I had previously, I had done a variety of different litigation. I had done sexual abuse cases, sexual molestation cases. I had done medical malpractice. I had done essentially a lot of, I had taken on Burlington Northern Railway and for wildfires that they started. I was selected as lead trial counsel. Well, as lead trial counsel, I felt it would be a conflict for me to be have one of my clients in this particular set of Bellwether Trials. So you asked what the Bellwether Trials were about. It was to determine if we could prove specific causation with regard to these 5 clients, and whether or not, if we could prove that, what the appropriate compensation would be. And I should mention right now, Kirkland and Ellis, okay, I don't know at which time, but they had 47 lawyers working on this defense of this particular case. We already knew by the time we got the Bellwether Trials that, based upon information that we had received, that the government had already spent $50 million, okay, in attorney fees and costs defending this litigation. Obviously, the plaintiff groups had nowhere near that kind of financing. This was all a whole new area of type of litigation. So I think overall, throughout the whole entire length of litigation, I think that what was spent, or what the plaintiff lawyers came up with, was approximately $10 million. By the time the entire case was over, not counting out what was paid in compensation, just attorney fees and costs, I have heard that the government, which is us taxpayers, okay, spent over $82 million defending these cases. So we, and that's one of the reasons that it was so difficult. But our judge, Frame Nielsen, before the Bellwether Trials even occurred, had a series of motions. He wanted to know whether or not we could even prove the case. And in fact, there were appeals before we ever got to the Bellwether Trials. The first one was on general causation. And at that time, there were 2 different major lawsuits going on. One was called the Berg case, and one was called In re Hanford. In re Hanford went to the Ninth Circuit Court of Appeals, and Judge McDonald, who had thrown out approximately 95% of this particular case, He was reversed by the Ninth Circuit. General causation was found to be proven, and then we moved on to essentially having to come up with the experts in the particular case that could prove specific causation, and of course, obviously, what the damages would be. The defense before the Bellwether Trials essentially, well, I'm not sure who moved first, but liability in the case was put at issue, okay, along with many motions regarding experts under what was called the Daubert standard. And as it turned out, Frem Nielsen, after reviewing everything, he granted, as it turned out, the plaintiff's motion that this matter would be tried as strict liability. So the government then knew that they were on the line, at least for general causation, and that their negligence was essentially strict liability. So we were past having to prove that, for lack of a better term, that the government was at fault. But what was left out there was a specific client, did the government's negligence, okay, or their fault, did it cause a specific Downwinders disease? And that's where we went forward into the Bellwether Trials. And so it was a complicated trial. The two with thyroid cancer prevailed. However, the amounts that they received were not a surprise to me, because they had been caught early. This lady and this gentleman, their thyroid cancer had been caught in time by the medicals. They removed the thyroid. They were able to stop the progression of the cancer within their bodies. And so the verdicts of around 250 to 350,000, for me, I felt was quite reasonable. For somebody like one of the other clients that we tried, and I can't believe I'm not remembering her name right now.
Rhodes? Shannon Rhodes?
Shannon Rhodes. What an incredible lady. She had thyroid cancer, and it metastasized throughout her body. And her, in the original trial, Bellwether trial, she had a hung jury. In other words, they could not agree on whether or not Hanford had caused her particular disease. With the two other ones, the hypothyroid cases, we lost those two, but later those were settled favorably for those two clients, which was always an indication to me that the government didn't really want to go forward trying those particular cases, because they knew that given the great number of them, that it could become very costly if we ever had any Bellwether trials concerning the hypothyroid disease, which was related to the same thing that the thyroid cancer cases evolved from. But in any event, the second Bellwether trial was the retrial of Shannon Rhodes. And by the way, we found out from the jurors after the first trial that we came within one juror of prevailing for Shannon Rhodes. It was a 9-3 plaintiff's verdict. And in this particular case, even though in federal court, normally in federal court, it's a unanimous verdict is necessary. But both sides stipulated that a 10-2, which is necessary under state law in the state of Washington, plaintiff and defendant agreed to that. And so in the second trial, we were told that originally it was pretty much deadlocked again, but after 2 or 3 days of deliberation, it turned around and we lost that particular case. So you should ask me about the doses that were ascribed to the plaintiffs in those Bellwether cases.
So the next question I had was, what sort of doses were ascribed to the plaintiffs in the Bellwether trials?
Okay. Heading into that particular litigation, the plaintiff lawyers had already spent millions of dollars on their experts. The defense had an entire team of experts indicating that the doses that came from what's called HE header, okay, that those are the kinds of doses that were the real truth. We said they're not the truth at all, that they're flawed, and scientists had been coming forward, but unfortunately, the vote among the plaintiffs' counsel, which, by the way, was a fairly dysfunctional group throughout the litigation. You know, I'm being transparent. It was, okay. It seemed like every group had a different view of how we should proceed. But one of the things that's really unfortunate, and I've already said this before, I said this in the National Law Journal years ago, it was unfortunate that the plaintiffs stipulated with the defendants to use the header doses. Shannon Rhodes had a header dose of 6.9, okay? The other two that prevailed had doses between 25 and 30, and I'm talking rads, and I'm not going to get into a discussion of what a rad is. But our expert with regard to Shannon Rhodes said her dose was over 82. That would be plenty to prove causation for her disease. She lived, and I went down to her house where she grew up. She lived in this area right here, south of Spokane, in a place called Dusty, Washington. And that's where she grew up. That's where she was when she was a little kid. And she ate vegetables, and she drank milk, and she did all the things. But Header said her dose was 6.9 rads. Okay, ours said it was over 80, I think 82. And it was extremely disappointing for me, having tried both cases, to see her essentially near death at the time of the trial lose that particular case. And her only words at the end of that second trial, Bellwether trial, which had to occur because there was a hung jury the first time, was that she hoped we could never ever stipulate again to the header doses, and thereafter essentially we refused. But we never got another trial. We never got any relief from the court about actually putting on the trial. That occurred because of some of the division between the plaintiffs' counsel. There was plaintiff counsels at that time, and I won't get into names, but essentially decided to throw in the towel. That they had already essentially exhausted their savings accounts. I know one lawyer mortgaged his house to continue forward. Another one had other things he wanted to do in life. And so instead of forcing the issue of going to trial with another Bellwether trial, or at least getting that on board, I think the judge saw that we had stipulated to header, and once we stipulated to header, we're stuck with header. Tom Folds never gave up. And of course, I was working with him. He and I were closely connected through this entire litigation. And so we never gave up trying to get what we believe to be the proper doses on the table, or at least have the header dose fighting against what I would call the Crawford-Brown dose, of getting that in front of a jury so that the jury could decide, is the header dose the appropriate dose, or is the Crawford-Brown dose? And we had other experts on that backed up Crawford-Brown. Never got there. And so that's when settlements late in the litigation started occurring, and I think the judge felt that this needs to end. This can't go on. And here we were fighting the judge on this, in addition to very articulate and very persuasive defense counsel. There was one particular client who I came to know because I went out to her farm when she was a little kid. It's this lady here. And Deborah Clark had already lost a sister to thyroid cancer. She grew up on a little farm near a town called Umatilla, right on the Columbia River. And Deborah Clark already had thyroid cancer, and I learned from her by going down to where she grew up that her dad owned a dairy, a little dairy, 12 cows, and they supplied milk to people in Umatilla and to Pendleton. She had already had surgery on her thyroid. At the time that I went down and visited her, she had a hole right here in her neck. And the only way she could speak is to put her finger over this hole in her neck, so that you would be able, she'd be able to raspy tell you about her life. When I said spin, the header dose, according to Mr. Van Wart, the lead trial counsel for header, said that her dose was less than 1 rad. Okay, less than 1 rad because she was not around when the heavy doses came out. But I started doing some investigation into when she was born and what had happened around that time. The Green Run was a top secret U.S. government release of radioactive products, okay? This occurred December 2nd and December 3rd of 1949, okay? And by the way, this lady was born 12 days later. This was a release that was to be detected by the United States Air Force, okay, with reconnaissance extending out some 500 miles. They had the planes ready to go to determine what the radiation was, radioactive iodine, that was being transmitted throughout the air, how far it would go, how fast it would go. There was, however, okay, this planned release, okay, encountered a problem in that there was an unpredicted 2-week weather inversion that we were able to determine occurred around that time, which essentially did not move the upper level winds. They stayed within 100 miles of Hanford. Sources indicate that this release alone, okay, out of the 550,000 curies that were released, this one released up to 12,000 curies into the air, and an even a greater amount of another radioisotope. But in any event, instead of being blown downwind into Canada and faraway reaches that the Air Force was prepared for, it hung around northern Oregon, the basin, which we call here in eastern Washington, and a bit into Idaho. And it was there for over 2 weeks. This lady was born, okay, while that inversion was going on. So she was an infant in Pendleton, Oregon, where she was born at this very time. The defense in this particular case refused to even take this inversion, the Green Run, into account. What we heard in court was she wasn't born until after the Green Run, and so why are they even bringing this up? I tried to get her, when I found out that from her doctor that she had 1 year to live. That was the prognostication, that she only had 1 year to live. And I went to court in a motion to give her an expedited trial. And the defense came back and said this was a stunt. Okay, the plaintiffs are pulling a stunt here. Okay, what they're trying to do is they're trying to get out of what the court's already decided is a planned avenue to determine the resolution of all of these cases, and why they want to favor this one lady with an expedited trial when all these other persons, okay, are not getting a trial, is essentially an affront. And of course, what Mr. Van Wart said is words that this is, I can't believe that the court is even going to allow this to occur. And the fact that they're bringing it up, they're trying to cherry pick this one lady to go forward, okay? She had the true story of what happened, and according to our experts, they had totally miscalculated in Header and the other government study what the real doses were during the green run. Now, the green run was a very small portion of the total amount of radioactivity in terms of curies that had been emitted upon the public. But in any event, that green run that I just spoke of turned out to be so serious and so worried the government that they called a cessation of any more experiments like they had just done. And what they did during this thing, something that the defense and Hanford refused to really admit to, but now has admitted to, because this was an intentional release of radiation to find out. And it was essentially because they wanted to check to see what Russia was doing with regard to their development of atomic weapons. That was a real reason for it, and that's why they had this special intentional release. What they did was they removed all the filters that they had at the stack. So they removed them so fresh radioactive iodine, okay, went out into the air, and then, as I said, hung over the basin, hung over this 100-mile radius of Hanford at that time. That was not the only thing that the green run did. What they had been doing, green run's given its name from processing of the uranium. In other words, it's an open loop water-cooled nuclear reactor for the plutonium-239. And so essentially it meant fresh radiation as opposed to what they had been doing in protecting the public downwind of going to a longer decay time of, they were going to a decay time of 83 to 101 days as of 1949, because originally they were using essentially the same as what they did during the green run. And so what they did, they put fresh radioactivity into the air, and this was all in the production of what was 30,000 nuclear weapons of various types that were amassed during the Cold War by the United States. So they intentionally made it fresh, and they essentially, these two studies done by the government, which were the foundation for Header, according to things that I have read, essentially grossly underestimated the amount of radiation that went into this lady and a lot of other kids and adults even at that particular time. You know, if defense counsel were to hear or read or listen to me today, they would say, where did you come up with all this information? Well, I read, okay, and so and I've done a lot of reading. I did a lot of reading throughout this particular case. In fact, I can tell you, when you get stuck in a case like this, and I was in it at the very beginning, I got into this case in a very unusual fashion, okay, in which another plaintiff's counsel essentially was in the course of being removed from the case for going out and signing up downwinders who really, some of them hadn't even been in the area at the time. But I don't want to get into that particular story. But once I got into it, I knew that I was into something that I really needed to study. So what I started doing is I started pulling every book I could possibly find on this subject, okay? And these things are like the state of the art of occupational medicine, nuclear energy industry. This one, dog ear, this is Bear 5. And there was Bear 4 before this, and there might even be a Bear 6 by now, I don't know. But, you know, you can't do litigation like this as an attorney without preparing. And there were other books that were coming out, Nuclear Witness. There's a big fat one, Elements of Controversy, the Atomic Energy Commission, Radiation Safety, and Nuclear Weapons. I have this library this is Final Warning, The Legacy of Chernobyl, okay, Exposure to American People, Iodine 131. This is a review of the National Cancer Institute. This is The Nuclear Age. 3 Mile Island, Nuclear Radiation, Risks and Benefits, Our Radiant World, The Making of a Real Killing, okay, Rocky Flats and the Nuclear West, Dragon's Tail. This is a very interesting book, by the way, Dragon's Tail. This is Justice Downwind, America's Atomic Testing in the Program in the 1950s. This is half of the ones, Operation Crossroads, the atomic test in the Bikini Atoll, The Art of War, okay, and it's all about atomic weapons, atomic bombs, and the nuclear barons, the making of atomic bomb. And then you also, if you want to be really prepared, I wanted to know what was it like down at Hanford. So there were larger books with lots of pictures in them, lots of drawings that helped me get up to speed. And it had the other places like the Lawrence Livermore National Laboratory, so the plant. And then I was really interested in this one, Tri-Cities Memories. And it goes back to, essentially, there's a ton of pictures in here about how they built Hanford and the people that were there, unknowing at the time that they were being exposed to all this radiation. There's a whole section on here of what it was like. So I spent a lot of time reading as much as I possibly could. And you don't go into litigation like this without being well informed, okay? Whether I'm doing a sexual abuse case or I'm doing some other type of case, you have to get prepared. And what I kept hearing from the defense in this particular case is they were ignoring all of this stuff, essentially ignoring information that had already been documented. It was already out there. It was as if they were creating a whole new history that didn't really exist. And so, and we would go to court. You know, I was asked here recently what it was like to be, maybe I'm perhaps answering my own question with regard to what it was like to be in this particular litigation. But for me in this litigation, my paralegal who endured me for all these years in the Hanford litigation and my other litigation was asked by a particular legal organization, and they wanted to award me with Trial Lawyer of the Year, but they didn't have a trial lawyer for a quarter of a century. So they decided to give me this award, and I'm not trying to pat myself on the back here, but what she did is really interesting, and that's all I'm going to tell you about, is what it was like to be a litigator in this particular Hanford litigation. So unbeknownst to me, she put this information together and provided it to those who, to Jan Eric Peterson, who was a Downwinder lawyer here in the state of Washington, and he presented me for this pretty large plaintiff and defense-oriented legal group. And so I was surprised to hear him get up to provide this particular award 2 or 3 years ago, in which these numbers came out. I represented, in the end, 707 Downwinders. At that time, it was 23 years of litigation. There were 3 appeals to the Ninth Circuit Court of Appeals. In this case, there were 67 status conferences in the court. And that has to be a record, okay? In most cases, you have 2 or 3 status conferences. In this one, there were 67 status conferences. I attended 116 depositions. Depositions are where the defense would ask questions of plaintiff's counsel or of experts for the plaintiff. We did very few, were able to do very few depositions of defense counsel, but in any event, I attended 116 depositions. At one time, I had 615 banker boxes. Now it's been reduced down to 304 banker boxes, which are stored just outside of this building. So even with that many banker boxes, I still am in possession of over 600,000 pieces of paper, pages of information. In this particular case, I had to answer for my clients 28,987 interrogatories. And you have to essentially sign off on them that they're accurate. So that meant that did hundreds of interviews, got medical records for these people that would come in, and where are you even going to put them? There were so many. In this particular case, we had 73 experts that dealt with this case on the defense and on the plaintiff's side. As I said, there were the 2 Bellwether trials. Personally, my firm put in 17,000 hours into this litigation, and I put in over 10,000 myself. So it was not an easy task. And I know that lawyers like Tom Foltz, he gave 24 years of his life, okay, where he did nothing else but work on this case. So essentially, what went into this from the plaintiff's perspective, it can't even really adequately put into words. And what's for me was extremely unfortunate and disappointing was that we couldn't get more compensation for our clients, for these downwinders. But I can tell you this, no matter what we got, or even if we didn't get them something because of these doses that had been agreed to, and we couldn't get to trial on many of these cases, hundreds of them thanked us, came back with letters, with notes, with phone calls. Thank you for finally making the government take responsibility. That was the one thing that we got out of this case that was heartwarming to me and made it feel like it was all worth it. I'm not so sure my partners would agree with that, because I think that we came out overall over $1 million in the hole from representing, and I'm talking about dollars, in the hole from representing. Yes, we did get some fees out of the particular case. We did get some costs compensated, but overall, it was one of those things in which you did it, and I'm still proud of it.
I would like you to explain, please, why the taxpayer ended up paying for the defense. I don't think people will quite understand the indemnification or what Price Anderson is, just in sort of simple terms.
When they wanted to make the bomb, when the Manhattan Project, okay, and I hope I stated accurately, the United States government could not find a contractor to build Hanford. It knew it wanted to, but it could not find a contractor. Finally, DuPont, and it's Dumors or whatever it is, at that time finally agreed to build Hanford for $1. $1. Okay. But what they wanted was, they wanted an indemnification for all time, infinity, that it would not be responsible for any damages, injuries that would be caused by any United States citizens in building Hanford. And so DuPont went ahead and built it. General Electric took over after a short period of time. We're paying in two ways as taxpayers. Number one, with regard to the defense of the case, the Department of Energy. But with regard to how did the taxpayers wind up paying for this, it was that contract that was entered into between the United States, in other words, to indemnify. A congressional act came along called the Price-Anderson Act, okay? Some congresspersons and senators realized that we need to do something to compensate individuals who are victims of essentially nuclear disasters, okay, or nuclear programs that cause them harm. And so that particular act was passed for the immediate and just compensation of those who had been harmed. It was a nice idea, but everything still fell back on causation. Did this individual, did this nuclear event, i.e. Hanford, did it cause their specific disease? So even though it said the just and speedy compensation, getting to the just and speedy compensation for the Downwinders never occurred. And so there was no teeth in the particular act with regard to making things move along faster or making the Department of Energy adhere to the same kinds of things the Department of Health had determined was caused by Hanford. It always amazed me, all these cancers that the government paid for, and it was a small amount, but it was something, $150,000. If you worked at Hanford and you were subjected to radiation, and you could show that you were there during a certain period of time, you were compensated with $150,000 for all kinds of different cancers. Okay, the only one that the Hanford litigation ever got to was radioactive iodine. And so, as I said, the Department of Energy, they had their own program and refused to adhere to anything that the Department of Health thought was appropriate under the Price-Anderson Act. We're all paying for the cleanup at Hanford right now, okay? It changes every year, okay? I can remember when early on in this litigation, the cleanup at Hanford was estimated to cost about, I think, $2 billion. Well, now we're up to $2 billion. Okay, now they're talking that it's going to cost approximately $45 billion to clean up Hanford, and where it used to be supposed to be done next year. Okay, now they're saying it's the cleanup of Hanford and everything that exists down there won't be done until essentially 2079. And that's the more and I've been involved in litigation involving whistleblower, False Claims Act cases against the contractors to this day. Okay, did they learn anything? I don't think they have, but that's my own personal opinion. I think that some of these contractors agreed that they had been misleading the public, misleading the taxpayers, because the case that I was involved in, and I played a small part in that case, it settled for $125 million. Most of that went back to the government under the False Claims Act case. But if these contractors are willing to pay, or one contractor is willing to pay, actually it was two contractors, willing to pay $125 million, well, okay, where there's smoke, there's fire. Okay, something smells, and it smelled for a long time. But obviously, I've gone ahead and talked about where other taxpayer dollars. But $45 billion. That's that's a tidy sum.
Well, I wanted to go back to one question I had on. Would it be, if Price-Anderson were amended to put a cap on defense spending, would that make even the playing field a little bit? I mean, that was one of the problems, I think, that it was just way too much funding coming out of taxpayer dollars to fund the defense, so it prolonged the litigation, made it harder on plaintiffs' counsel. Do you think that that's a reasonable amendment?
Well, this would all be post Hanford litigation.
Right. Yep. Yep.
That's an interesting idea. I can certainly tell you that Department of Energy is going to be in there screaming bloody murder, okay, to cut off their funding or reduce their funding. And of course, law firms would be saying, how can we adequately represent the taxpayer without getting everything we possibly need to defend this case? Okay, their view is that that some of these claims weren't legitimate, that some people were making up stuff. Interesting idea, but I'll bet you can never get it through Congress.
Yeah. The trial. One thing that's always intrigued me is the Pigford report, that report that was sealed by Judge McDonald for years. In fact, it was under seal for 9 years. And Judge McDonald not only sealed the Pigford report, which was done by a prominent nuclear engineer from Berkeley, but he also forbade any kind of a discovery on HEDR and HTDS studies during that time. And I'm wondering if you think that made a difference. I mean, the reason the timing is interesting is because Pigford was saying that HEDR, because it was not evaluating the topography and other unusual variations in Hanford that could have affected the doses, that HEDR and Battelle were likely underestimating the radiation doses. And since you later, or most of the plaintiffs agreed later on to speculate to those doses, would it have made a difference had the Pigford report come out much earlier?
It probably would have. As you know, Judge McDonald wound up with his, shown that he had his hand in the cookie jar, okay? And so he may have had a very good reason for trying to bury the Pigford report. Did it change Judge Nielsen's view? Yes, I think it did with regard to general causation, because he ruled strict liability. He had the Pigford report in hand, and he saw that this probably should have been done by Judge McDonald years ago. Mm-hmm. Would it have changed the course of the litigation? Perhaps.
When you mentioned that Judge McDonald had his hand in the cookie jar, could you elaborate on that when you said?
Tom Foles is a better. Tom Foles always said, "I smell a rat." Okay, he didn't say a mouse. He said, "I smell a rat," and so I don't know whether Tom has explained that situation, but he was the one lawyer that thought that something is awry, and as it turned out, Judge McDonald had land that he wanted to develop into apple orchards. And apple orchards are a big deal along the Columbia River, running from Okanagan all the way down to essentially the Tri-Cities. And he had this land that he wanted to turn into apple orchards. And he had to sign an affidavit to get a loan from the Small Business Administration, a fairly large loan, to develop these apple orchards, that essentially there was no radiation on any of this land, okay? And so when you look at the map, there was indeed definitely radiation adjoining the Columbia River. It had been proven by different readings for those radionuclides that don't go away in just a few days. And so Tom Foles brought all this information out, and with that, the Ninth Circuit, whether it was the Ninth Circuit telling him you better resign from this case, or we're going to do something about it. However it occurred, he recused himself from further litigation in this case, and it was transferred to Judge Frem Nielsen. I think Frem Nielsen wanted to be fair throughout. But, essentially, Frem Nielsen, he was thoughtful, but in the end, the whole entire litigation turned into one of, let's get this done. However we can possibly get it done, let's get this done, okay? And when a couple of the plaintiffs' counsel saw that coming and not having the resources to be able to go to trial for their clients, started settling cases without other plaintiffs' counsel even knowing about it. And once Judge Nielsen saw that these cases were settling far less than what the rest of the other plaintiffs' counsel thought would be the bare bones minimum, settling for even less than that. It was a train that was heading down the track, and there was no way to stop it.
Okay. Let's see. I wanted to go back to the two Bellwether thyroid cases that were the Stanton and Wise who won their cases. And you noted that it wasn't for a whole lot of money, you know, a couple, $250,000, $265,000 each. But weren't they still pretty significant in that juries decided in favor of two thyroid cancer plaintiffs in those cases where, correct me if I'm wrong, but the other big decisions, like the Utah cases, had come from judges who were later overruled. But was this one of the first or one of the first jury verdicts in the United States court system that actually found for victims of a nuclear?
Yes. Okay, I'm not aware, and perhaps I could be wrong, I'm not aware of any other verdicts arising out of the Price-Anderson Act. These particular verdicts for thyroid cancer, as I said, I think one was around $250,000, and another one was $350,000. And they essentially were cancer-free, and they were going to live the rest of their lives. For someone who is recovered from cancer, it was caught early. They had the thyroid operation. They definitely were within the range of what I would say at that time would be reasonable.
Okay. As the trial was going, as the whole litigation was proceeding, so were these studies, both Header, of course, and then later the Hanford Thyroid Disease study. How much did that sort of disputed outcome of HTDS, did it hurt your case a lot because you weren't able to specifically pin a dose to an outcome?
I don't think the defense was really wanting to even they indicated that this was a legitimate study that was done, even though if you go in and look at the authors of those particular studies, like Judge McDonald, I think they had their hand in the cookie jar all along. Okay, they had a reason for backing up what the government had done in the Manhattan Project, and for their own purposes. Some of them had worked at Hanford, and now they're judging whether or not the doses that these people were getting or had gotten were reliable or not. But here was the government defending these cases, but it also financed these particular studies. And not only that, but Kirkland Ellis had a couple persons who had been involved in the studies themselves. How much they were biased. My personal point of view is there was bias. The extent of the bias, I guess, would not be for me to judge, but there was bias in those studies. And unfortunately, with the defense doing the kind of defense they were doing, which is my opinion on that, they had a scorched earth defense. Scorched earth defense is where you do everything you possibly can to defend, and you don't care about the morality of it. You don't care about what it means for future generations. It does not mean about being fair and honorable. When Folds and myself had been digging into documents and receiving information from other persons who had been investigating for other purposes, the Hanford Environmental Group. I'm sure that even after today, that there still will be information coming out about Hanford that we never knew existed. I can remember, interestingly enough, when you talk about bias, Folds had gone to the trouble to go down to Hanford. And I joined him at Hanford to what was called the Hanford Library. And there was an absolute trove of documents, boxes and boxes of boxes about the building of Hanford, the contractors, and Folds essentially wanted all of that information. However, I believe it was about 2 or 3 months after we were there, while Tom Folds was making arrangements, okay, and this is before, you know, scanning was an art, okay, to the extent it is today. For some reason, all the fire valves for their water, for their fire system went off in the library, and so boxes and boxes of documents were soaked with water, okay? And I heard that they were trying to dry them out, okay? And Tom Folds probably could give you more information about the soaking of the Hanford Library down there, and what he was able to get out of there and not be able to get out of there. But I just thought it was very coincidental that those fire, what do you call those things?
Sprinklers?
Sprinklers. The sprinklers went off in their Hanford Library. Before, as Tom said, a lot of documents that he had requested had been shipped off to him.
Now, regarding the final settlement amounts, you know, in 2015 when the global settlement was announced, why were they kept confidential? Was it a government decision or what? How did that?
I mean the settlements.
The settlement, the dollar, yeah, the confident. Why were they considered confident after all the taxpayers had paid for them, their public money?
You probably find this kind of interesting. Okay, this was a way of protecting those who were compensated. It had nothing to do with we gave the plaintiffs who settled choices with regard to whether or not the amount they received would be confidential or not. Almost virtually 90% wanted their settlement amount confidential. They were very happy to get it. But the reason that most of them indicated to us that they wanted it confidential was because some of them got more money than others. And we had one sister that would get one amount, and another sister that might get nothing, or another brother that might get a much smaller amount. We had those who didn't want anybody knowing that they had any money at all, okay? They didn't want people coming to them asking to borrow the money. And so there was a lot of discussion. Now, I can only speak for my clients and Tom Folds' clients. What occurred with regard to those represented by Mr. Haber, those represented by Berger Montag, those represented by Brian Depew. I can't answer for any confidentiality, but I know there were confidential settlements, and if there's confidential settlements, does that make the total amount discoverable? I always thought that the media would find out what the total amounts were. And I guess you're telling me you never were able to find out what the total amounts.
Not yet.
But you'll be disappointed because in my view they're horribly skimpy. Compared
to the figure you gave of what, $84 million that was paid to the.
Sure.
Yeah.
I mean, some of these people wound up with $5,000. Some wound up with $10,000. Some of those with thyroid cancer. I think the highest well, I won't say what the highest was because I don't know for sure, because I don't know what some clients for Mr. Depew, and he had an entire group, you know, he was doing, in the end, work for 2 or 3 different law firms. So I can't tell you what the higher amounts were, but I know that a lot of the settlements were very low.
But do you think that the judge turned too much of this over to the judicial mediators at the end? The whole case seemed to move to the mediators in the mediator in Oregon. The mediator in Spokane, I'm sorry.
Well, that was the plaintiffs' counsel, Tom Foltz and I. We felt the only way for those that they were willing to compensate. Okay. As lawyers, we don't want to make the determination as to what was fair. And so we came up with that plan, okay, where we would have them go through an interview process, either by video, or if they wanted not to be on video, to be in writing. And so we accumulated information on what we believed to be their dose, their injuries, their damages that they felt, and then all of that information was provided to the mediator. Okay, and what, and his name was William Etter, a very fine lawyer. He used to be quarterback for Notre Dame before he ever got into law school. I think he was a quarterback before Joe Theismann, who famously broke his leg. But in any event, we chose him, and the defense went along with that. And so what he did is he very carefully and thoroughly talked either in person or on the phone with those who were receiving money, okay, to determine out of a block of money, you know, how to divide it up. And you know what? There wasn't a single plaintiff that came back and expressed disappointment over how he had divided it up. The only thing I have to add at the end is that so many of these people passed away. Or it started out as Downwinders, became sick, endured it all of their lives with all kinds of different problems, and then died without even knowing what their compensation would be. At one point in time, my firm wanted to put an ad in the New York Times and the local newspapers here showing photos of those who had passed away as a result of Hanford. And so we collected all of these photos of those who had already passed away, and we never got the opportunity to actually put that ad in the newspapers. So because we were too far into trying to figure out how to get some compensation. I alluded to the problems among plaintiffs' counsel. It's one of those unfortunate things. You get people who have run out of, lawyers who have run out of money to go any further. They wanted, you know, some still would like to get some compensation out of the case, get reimbursed for, you know, hundreds of thousands of dollars in costs, and then there's those who don't want to give up to the bitter end. Okay, and the last 3 in the case, if I remember correctly, were Depew, and after he settled the rest of his cases, that left Tom Foltz and me. And I finally was the second last to go, and at the very end, Tom Foltz was the last one to stay into the bitter end. Okay, but still, I was working with Tom Foltz even through the completion of his settlements. Okay, you know, that guy, he put the whole rest of his life. Okay, well, he's still alive. Okay, and he's still going strong. I think now he's about 94 years old. And I'm still in contact with him. But what an amazing mind that guy had, and his understanding of the truth helped me understand what the real truth was in this particular devastating situation for so many different people. And it's going to continue as they try to clean up Hanford. I mean, if people think that everything is safe down there, it's not. I know enough from the additional litigation that I've been involved in involving the contractors and the cleanup that there are tanks down there that are leaking and are extremely volatile, and just pray that that we don't have a catastrophe where several of these tanks blow up. If one blows up, there's others adjoining nearby that can blow up, and if they do, you want to run. A lot of these people were victims. Very suspicious that everyone in my family who stayed near Hanford got tumors. Did my daughter get 9 holes in her heart because of where I grew up? Thyroid disease, breast cancer, 6 tumors in my uterus. I'm surprised I don't glow in the dark. Three years ago, I discovered I was exposed to radiation. What a relief. And that's the attitude that a lot of these people had. Thanks to the FOIA request, thanks to the work done by the lawyers in this particular case, the media stepping in and covering it the way they did, just knowing that there was an answer to these people for all the diseases, whether it was brain cancer, bone cancer, all the different kinds of cancers they would have gotten from radionuclides out of the river, and those that came through the air, iodine, just knowing that they were not unlucky in life, that actually there was an answer for the cause, and that the cause arose out of the Hanford radiation that was emitted out of those stacks and went into the river.
Have there been other organizations that have stepped forward and say, you plaintiffs' attorneys did a really, really good job in a significant case in our nation's history?
Tom Folds and I received the award from the Washington Association of Justice for the work that we did. Okay, it was, I don't know about other lawyers in the case. Essentially, there was just 6 different groups. But he and I were recognized for the work that we did, and it took so many years. The recent award that I read from, where they did some investigation into what my firm and I had put into it, that was a national organization called ABOTA. It's half plaintiff lawyers, half defense lawyers. Okay. And as I understand it, the defense lawyers were the ones that selected me to get that award.